Good morning. I'm Alec Donaldson. I'm a partner at Wyrick, Robbins, Yates, and Ponton here in Raleigh. I practice in the corporate and security space, predominantly with public companies or companies looking to go public. And joining me on the panel is, to my immediate right, is Raina Haque. Raina is a professor of practice of technology at Wake Forest, who focuses on computational law and emergent technologies. She's also the founder and lead attorney of Erdős Intellectual Property Law and Startup Legal. Prior to joining the legal profession, she was a fintech business analyst and software engineer at a major Wall Street financial firm in New York. She was a research fellow at the National Institutes of Environmental Health Sciences and the Neurotoxicology and Nuclear Magnetic Resonance Labs, working on artificial deep neural network applications. She's among the first patent attorneys to work on the blockchain technology space and has written several articles on guidance on IP-related matters. She also is a leading contributor to the North Carolina Bar's Future of the Law annual report on blockchain technologies. Next to Raina is Jeff Truitt, who's with Securrency. Securrency is a combined fintech, regtech platform that enables the free trading of previously illiquid asset classes. Securrency makes financial services more secure, transparent, efficient, and accessible by integrating legacy financial services with recent advances in distributed ledger technologies, payment gateways, and security frameworks. At Securrency, Jeff ensures alignment of the company's technology platform with regulatory requirements as well as business needs. Before joining Securrency, he was a shareholder in law firm of Smith Anderson here in Raleigh. Immediately prior to joining Securrency, he practiced corporate and securities law with Sidley Austin in their Chicago office. And rounding out the panel is Elizabeth Land Davis, who's with the law firm of Murphy and McGonigle in Washington, D.C. She is a former chief trial attorney for the CFTC's Division of Enforcement, where she was responsible for investigating and litigating potential violations of the Commodity Exchange Act and the Commission's regulations. In their connection with her work with the CFTC, Elizabeth worked with the SEC, the FBI, FINRA, state regulatory agencies, and foreign regulators, among others. Prior to her 9-year tenure at CFTC, Elizabeth served at the U.S. Department of Justice for 9 years in the tax division. All right, the title of this panel is Initial Coin Offerings and Compliance, Lessons from the Past Year and a Look Ahead. And we got a real look ahead on Thursday with the SEC's William Hinman's comments on this topic. But before we get to those comments, let's take a look at 2017 and how we got to the position laid out by Mr. Hinman. So in 2017, clearly we have an enormous increase in ICO activity throughout the year. Naturally, the concern then emerges during the year over the securities laws and are in fact ICOs, not securities offerings. So, at the risk of boring those of you who may have already looked at this, let's get a little bit down into the legal weeds. So, any security, if it is a security, must be registered or exempt from registration, both federal and state. Well, what is a security? Are ICOs in fact a security? So where it is not clear, like a bond or a stock share, you revert to the four-part Howey test, which has been around from the 30s. And a security is involved if 1, there's an investment of money, 2, in a common enterprise, 3, with the expectation of profit, and 4, from the efforts of others. The two main elements that we're really going to talk about today and that have really been shaping the conversation are the expectation of profit from the efforts of others. All right, so let me ask one thing. There is that third prong about a common enterprise. And let me ask the panel, is that something we feel really need to worry about? Do you think it's almost inevitably present, the common enterprise?
What do you mean by inevitably present?
Well, I guess common enterprise, if you're talking about, if you're relying on the efforts of others, if somebody is developing a platform, is it by nature then a common enterprise? I'm giving you money, this is what you're developing. Just curious whether you think we need to really pay attention to that prong.
I think a way to kind of think about this is actually to go back to not just the Howey test, but the original framework for why does the SEC, why do these regulatory bodies even care? And to think about that, you really have to think about where they came from. They kind of came from a consumer protective standpoint. So what they're looking at is is how these tokens, coins, or whatever, how they're being promoted. Is it enticing people to kind of buy them with the expectation that there's going to be some kind of profit, return, or some type of right that becomes more valuable later on? So that's probably the first place to start before we start thinking about the language itself. To get down to the efforts of others, I guess, you know, in the Halley's test, it's hard to say because there isn't like, I think in Hinman's comments, which I just read like a little bit ago, you know, he talks about this idea of decentralization and how if something is truly decentralized, then it might not make sense actually for the SEC to go and regulate it in that way because there's no identifiable body to kind of go after. So maybe that leans more towards currencies, maybe commodities, rather than securities. So those are my initial thoughts.
Yeah, and I do think that it really gets into the common enterprise. That you are, to me, it is part of you're relying on somebody else. If there is that aspect of it, you've got a common enterprise rather than an exchange which is its own entity that you are just, your transaction really passing through. You have nothing to do with that exchange or to help to create or maintain that exchange.
I think ultimately it comes down to a facts and circumstances test, and I think that's where the SEC and the regulators, at least in the U.S., are going. You know, I think it depends on what exactly is, who comprises the common enterprise, what is the role of that enterprise in promoting whatever the token or product is, and I think that's where the analysis that's being taken. And if you look at Hinman's comments, he lays out towards the end of his comments what are the different factors and the questions to ask yourself, you know, that might help determine whether it is a common enterprise, whether you are decentralized or not, to be considered a security or not, at least under the securities laws.
Okay, well, in 2017, I view it as one of the milestones that really shaped the conversation. The first one was Andrew Chapin's very public campaign that he began this summer over his Benjacoin offering. He went public saying, I called the SEC, I'm trying to understand why this would be a security, and let me tell you why I think it's not. First of all, I told all these people, do not invest if you are looking for a profit. He already had an existing functioning platform. And he also, the tokens were only for use on that platform, even though he was developing or was committed to developing an exchange for those tokens, but their use was only for the on that platform, which it does comply, it appears, with the Howey test. He is clearly understanding that. Let me ask you this, maybe Elizabeth, only because you, having been a former regulator, a lot of people never like to go or really resist the idea of let's go talk to the regulators and see what they say. So any thoughts on Mr. Chapin's approach?
I think we're in an era that's unprecedented in terms of the willingness and the openness of the regulators. I can definitely speak to the CFTC as well as the SEC in my contacts with them, in terms of their willingness to want to get educated in the technology. Traditionally, the government is usually very far behind. It's usually bootstrapped for resources in terms of technology, so they don't have the ability to understand and appreciate the nuances of the technology, and the technology here is so complicated. And you're seeing with Lab CFTC at the CFTC, the SEC has an email address if you have inquiries where they are welcoming input. They want to be educated, and it's something you haven't really seen before. And you're also seeing now sort of the press that the staff at the SEC and the CFTC are out in the public domain. Traditionally, you've seen just the chairman of the agencies make their comments, but now you're seeing division directors, line attorneys, staff attorneys, and you see with Hinman's comments as to the direction and where the thoughts are of the SEC, and at the end of Hinman's comments, you know, he welcomed, you know, get your attorney, come in early, tell us, you know, whether it's going to be through interpretive guidance or exemption letters, no action relief, engage early. So I think you're definitely seeing an unprecedented level of willingness to be educated.
Yeah. I can second that. Securrency provides compliance tools for issuers primarily focused in tokenized securities, but abroad we can also do what I'll call traditional coin offerings through a subsidiary. And we've engaged in dialogue with the SEC over a period of months, and they've been very open to receiving us. We've met with 3 actual commissioners of the SEC, as well as separate staff meetings. We had a meeting a couple of days ago with the new crypto czar, Valerie Stepanek, that went for more than 2 hours to understand our platform and watch a demo, lots of questions. So there is tremendous openness, and I applaud the SEC and the CFTC for getting up to speed in this manner.
Yeah, at the state regulator level too, we've had discussions where they're saying, we wish people would come and sit down with us and just talk to us. And then I pointed out to them that, you know, when you are a startup, you're cash strapped, which is maybe why you're planning on an ICO. So hiring an attorney to sit down with you and the regulator can be kind of intimidating. And they said, well look, at this point we understand that. We really just want to get a base level understanding of the technology. And they're really asking members of the public to come educate them. So I think, like we were saying, like this is unprecedented, that they're understanding that there are enterprises that want to grow, that don't yet have the cash yet, but have the knowledge that these regulators really need to understand to move forward. So I think it's really good to try to take advantage of this time, you know, while you can, before the standard is like everyone lawyers up like heavily and then talks to the regulators. That's my point of view. It's always good to maybe run by what you would talk to a regulator about with an attorney. So definitely keep yourself educated in this space, but understand, all of us have notes up here because the space is moving so fast that we're constantly learning things ourselves as the attorneys that are the intermediaries between these startups and tech companies and the regulators.
Yeah. Just to add on to that, I think it's from that resource issue, it's better to engage early and educate as opposed to being on the defensive. And I speak from a former enforcement attorney. It's better to come in early on your terms than to have to defend yourself against a document request or a subpoena from one of the agencies, in which I will tell you those requests are very broad. You're going to be asked for a whole lot of information, you know, trading data, communications, your emails, your IMs, and whatnot, because the enforcement staff that isn't enforcement is always usually last to the party. So they're trying to get up to speed after the fact. So to the extent you can get in early and educate on your terms, you're in a much better position.
And as I was saying, I think that's what Andrew Chapin was doing. I mean, I think he very much was, okay, I'm doing this, but I'm going to go talk to you directly to get out in front. You can see I've got good intentions. They're not a defense. But, you know, and also I think it was a defensive measure. I've got this thing going on. I want to know up front if they're going to have real problems, so I've got to kind of force their hand. It didn't, but it started to shape the conversation. I think that was one of the most important things.
And notice too, like he does have candor, but he also hedged himself by stating everywhere, this is not suggested for U.S. people. You know, so notice that he actually looked at the standard itself to know that intentions aren't enough. Like he's actually going to have to show like maybe like comply with all these prongs of this test as well. So that's why he was front and center with that as well. So I think what he did was really smart. He also does have attorneys, which I'm sure kind of helped him shape the message. So yeah, I like what he's done.
All right. Another milestone in 2007 that came along was the July issuance by the SEC of their 21A report, which basically said those undertaking ICOs need to ensure compliance with the U.S. securities laws. Again, not a surprise, but really just putting the public on notice in light particularly of the frenzy building up over these ICOs, and clearly underneath it, the SEC was very concerned about the potential level, if not outright level, of fraud going on in numerous of these offerings. So the SEC really was just doing its job, but again, it was starting to say, people, you need to pay attention to this and let people know that that's something they're going to be dealing with. But again, the SEC, the way they work, they're trying to understand, they're trying to figure out how do we need to go down this road. They're not just doing a knee-jerk, but they wanted to put people on notice. Then we get to another milestone in October with the SAFT white paper that the Cooley guy put out, Simple Agreements for Future Tokens, where basically made the distinction between pre-functional tokens being securities, because you're relying on other people to build that platform, but post-functional security tokens, because they are in fact now a functioning platform, are not securities. Again, I think he was trying to seize the initiative and shape that conversation. So let me ask the panel your thoughts on his reasoning between pre-functional, functional, and how the SAFT experience or experiment went.
I think all of us have a lot of thoughts on that one. This has been a really fascinating space to watch, especially over the last year, because we've seen very smart people come up with initiatives, marketed as SAFT or whatever, that ultimately weren't successful, at least in the form that they were initially thought of. So it's made all of us, I think, step back and really consider, like, okay, where is the SEC coming from? What is their point of view in this? We're getting more clarity going forward. As we've been talking about Hinman's comments, the SEC regulatory body saying, please come down and sit with us. So I think, even the firms that were kind of promoting SAFT, like, they've had to walk back a little bit and pivot, as well as we've seen, like, the subpoenas come out from the SEC in January, and more regulators talking about how they view these things.
I think there's actually several audiences that you need to be aware of if you're trying to do something new in this space. And I'd say I can identify 4 separate regulatory audiences. One is the SEC staff, and that's what we've been talking about the most. But sitting above them are the commissioners, who actually have a different worldview than the staff. Sitting above them is Congress. And so we've been playing affirmative defense or preemptive defense by speaking to relevant members of House Financial Services and Financial Services and so on. And then there's another branch of government, so we've got Treasury and FinCEN. So we're very much aware that this is a nascent industry, and it can be shut down from a variety of directions. Terrorist financing is a concern. And so one thing that we've been doing is actually educating members in the Treasury, FinCEN, appropriate members of Congress about the capabilities in this space. So there's no knee-jerk reaction coming in from an unexpected direction, which definitely could occur. But through those meetings, I'll say that the commissioners are a little leery and staff. They're kind of skeptical of really novel arguments about why this is something totally different. The traditional rules don't apply anymore. The chairman told us, people come in, I'm paraphrasing, asking us to basically change the law. I can't change the law. I've got to enforce the law. So some of the arguments have been really novel, and I'll put these perhaps in that novel category. So we're seeing a steady march toward ultimately enforcement. These decisions started out with just raising awareness to freezing, and we're moving down the enforcement spectrum, which I'm sure you can address.
I think that's right. I mean, I think it's hard to come up with it'd be nice, but I don't think it's realistic to expect Congress or the government agencies to come up with a one-size-fits-all approach. And so by that, and let's face it, Congress is going to move pretty slow, and you're not going to see the rules get changed by Congress anytime soon. So I think you're going to end up seeing regulation by enforcement, by specific enforcement actions, again, going through the facts and circumstances of that particular product that you're offering. So you're seeing that in the SEC space, you're seeing that also in the CFTC space. And there, the CFTC, there is a decision out in Brooklyn by a very senior judge, ironically enough, saying that Bitcoin is a commodity, and the commission was going to take a position, and did take a position in a subsequent case in Boston that actually my partner is litigating on my Bitcoin Pay, where we're saying, no, not all virtual currencies are commodities. So that just had argument on Thursday, so the judge promised a fast decision, so we might get some more shaping to see, okay, are all virtual currencies commodities as broadly as the CFTC would like, or are we going to then truly have to look at particular commodities or coins rather? So we see now on the SEC side, same issue in this Lasky case where, are all virtual currencies securities or not? That's an SEC DOJ matter, I should say. And now we see Hinman's comments, yes, well, Bitcoin, Ether now are not securities. We're waiting to see whether Ripple is or not. So again, you just have to wait and see, and for that particular enforcement action to come.
And yeah, I don't want to leave the panel without saying this is something I have to educate on at the front, but calling something a coin or a token isn't going to make any difference to any regulator out there. So like that, that kind of, capsule you put on what you're doing, that's just not where the analysis is.
Yeah, form over substance is critical to the decision making here. And I would say as technical as this space is and as wide-reaching as it potentially is, we do not want Congress making a hasty decision because they're not well known for doing that.
And I can speak to that because I was at the agency post Dodd-Frank, and the flavor of the month then was swaps reporting, and they rushed through Dodd-Frank. I applaud their efforts. They had a huge task to handle post-financial crisis, and they came up with swaps reporting rules very quickly. But it was now we're at, I think, Reform 2.0. Commissioner Giancarlo just said. And you're going back and having to tweak those rules and move back to the practicalities of really what do we need to do. And on the enforcement side, having to enforce those rules, it was very, very difficult because they were put together so quickly. So here, I think there is that opportunity. Let's educate the regulators. Let's get the rules done correctly the first time, as opposed to having to push through these wide-ranging blanket one-size-fits-all rules to an area where maybe one size doesn't really fit all.
The signals I've seen suggest that they're not going to come out with fundamentally new rules for this space. They're being very cautious. They are aware that they could get it wrong, and that they're confident that technology companies will bring them capabilities that will enable issuers to get it right. They just sit back and proceed cautiously so they don't make a big mistake. And also, a couple of weeks ago, Commissioner Purewar announced that he's leaving in a few weeks. So after mid-July, the SEC will be 2-2 with Democrats and Republicans, and that will probably effectively restrict the ability for them to have really sweeping rules anyway, because there are some philosophical differences on the SEC.
All right, back to 2017, briefly. The last milestone that I think is significant was the 1-2 punch from the SEC with Jack Clayton's, the chairman's comments in December, where he said, by and large, ICOs that we reviewed at the SEC involved the offer and sale of securities. That was combined with the essentially simultaneous shutdown of the Munchie offering by the SEC. Clearly, it was a tactic designed to try to weed out fraudsters, and I would say that the great majority of actions the SEC has undertaken have been outright fraud, and I don't think anybody argues with that. But that they were really just doing their job from that perspective. But on the Munchie, again, there was no fraud suggested there. There were elements of that. Any idea why? Or what do you think about why the SEC went after Munchie, or what do we take away from that? It's constructive.
For the SEC, fraud is the low-hanging fruit, and then Munchie was not fraud, as far as, we can tell. But what they were doing was promoting that, these tokens will be very valuable later on. So again, we're looking at the kind of enticement of buyers with giving them some sort of sense or promise that this is going to be much more valuable later on. And this goes back to our discussion about, it's really substance over form. Is there an enticement to get people to buy in where, this starts looking like why securities law, blue sky laws came like over 70 years ago. So I think that's really what got Munchie in a bind. They did comply, once they got the cease and desist, they just shut everything down, which is pretty smart. But contrast that with what we saw with Benjicoin. You know, where he's saying, this is not a security, US buyers, you probably shouldn't be buying this. I'm being very candid here, and I'm talking to people. So compare and contrast those two things, and you'll see why Munchie kind of got slapped the way it did.
And the fact that Munchie did not have a functional platform.
Yeah.
Did. Again, that gets back to the Howie element of the efforts of others.
This can sound, this discussion sounds like, reminds me of a law school class, 15 or 20 years ago. And looking around the room, I don't think everyone is a lawyer, so I want to try to be more practical. I mean, we're, in a sense, we don't care. We help you comply. And so, unlike the people flanking me who are actually going to give you advice on what to do, we let our issuers retain their responsibility. But if I was giving advice, I'd say, look, what are you going to use the money for? If you're looking for non-dilutive capital, you just want to get money now so you can build something, that kind of feels like a security to me. If you're going to be able to trade this in later for higher value, that feels like it might be security. So a pure utility coin would be something that you're buying it and there's no way you're going to cash out later. I mean, it's pure utility, like a rewards card, like taking tokens to go to an arcade. You can spend it and consume it.
All right, so that gets us then to looking forward, and I think we got a big clue on Thursday with Hinman's comments where he said, where there is no longer any central enterprise being invested in, or where the digital asset is sold only to be used to purchase a good or service available through the network on which it was created, then generally that does not involve the sale of the security. So clearly relying on those two main prongs of Howie, the expectation of profit from the efforts of others. So what does this mean moving forward for 2018? Well, I guess let me ask you, is the Howie test alive and well?
I think so. I think it's definitely the standard that they're going to use when you come in and gauge the token, or not token, whatever the product is that you're coming in.
So I think after if you haven't, you might go Google Howie test. And a couple of days ago, Gary Goldschmidt, the Deputy Director of Trading and Markets, the SEC, actually held up a graph where over time, he looked at dual searches for the Howie test. It was kind of like flat. And then when the Dallas decision came out, it's like 6 times its historical volume. So it's definitely the test. And it's not only the test here, but jurisdictions around the world usually have a test that's something very close to the Howie test. So if you can be compliant in the United States, you'll probably be compliant anywhere in the world. So I don't know if we're going to talk about this, but I think the window for traditional coin offerings in the U.S. where you're trying to raise capital and not call it a security, that game's pretty much over. It's still getting some life in other places overseas, surprisingly. So you might still be able to go abroad, not sell to U.S. citizens. Not encouraging you to do that because who knows where the regulations will take us. But the market still has a life outside the U.S. in certain places.
And I think another thing that's really important to realize, like, even though we have this Howie test, understand, like, in the law, a word might not mean what you think it means at first glance. Like, you really have to look at the history of how that was applied. And the other thing is that, especially with the comments we saw on Thursday from Hinman, it's really interesting because he went beyond just, the 4 prongs of the Howie test. He talked about other factors that he would consider, helping, like the argument that this is a utility token versus some kind of security. So definitely read through that too, but understand that you really can't stop at just reading the language. You have to do more research than that. And it's also interesting that there was someone in this regulatory body who is kind of waxing more than he has to, and pay attention to that as well.
Well, what do we think? What do we think might be coming down the pike from the regulators? I mean, Monster Products is, as far as I'm aware, the only registration where they filed a registration statement for basically a token. But if the tokens don't work out, then you get stock. But they filed May 25th, so they're coming up on the comment period. They should be getting comments from the SEC. We're not going to see those, obviously, not for several months, if they go effective. But it'll be interesting to see what those comments are. And I don't know whether, Jeff, in any of your discussions up in DC, if people, is there anything that you could glean from that?
People are definitely being encouraged to apply for no action relief or exemptive relief. The SEC is I've heard them say on a couple occasions, face to face, we have not yet approved an ATS, an alternative trading system. So what 2018 and 2019 is going to be about is the tokenized security offering, where we acknowledge it is a security, it's issued in digital format. Just like we went from actual paper shares to book entry, these will be tokens that can be exchanged, issued and exchanged, and you can actually vote on your phone. That is definitely coming. I mean, my company, Securrency, has a tool to offer it. We actually have the ability to program the rules into the token, code the wallets, so the tokens cannot trade unless they comply with the regulatory exemption. Everyone who's seen this is just like, wow, we didn't know that was possible. There are a lot of people trying to get a similar concept. So I think that's the future. I think that people will go to the SEC, and when we get no action letters signed for these types of offerings, that will provide the comfort for institutions to flow into the space, and the industry will really take off. That's my prediction.
Well, and Hinman did say in his comments that we welcome, please send in for no actions, please come talk to us. But it will, with the Monster Products registration, I'm sure given the first, and given what discussions have been going on, the SEC will be paying particular attention to how they craft those comments. I look forward to being able to see those at some time.
Actually, Valerie Hispanic, I'm still kind of getting used to her last name, who's, I guess, recently appointed what's been called as the crypto czar at the SEC. She said something really interesting, too, is that, you know, it's not enough to turn a blind eye to whether, like, something's put on an exchange, that one of the things, like, she sees as maybe something happening is kind of what you mentioned, Jeff, is that we have, like, technological implementation to kind of restrict, you know, like if a security is offered or it changes hands, you know, beyond whatever safe harbor year or so. So you're also looking at, and she's a former patent attorney too, which I think is really interesting for two reasons. One, she's worked with entrepreneurs, which I think that's really good news for startups here. Two is that she actually understands the technology as well, what its capabilities can be. So perhaps like we'll start seeing a way forward there. Although technology isn't regulated, there might be some factors that they'll want to see in creating these platforms that help distinguish whether or not they should be considered securities or tokens.
She made those remarks the week before she met with us, and absolutely loved it because it was a perfect setup for a meeting. We actually nest not only rules for the primary offering, but the rules that will enable them to be traded in a secondary offering. So it's really cool.
All right, so do we expect, are we just, you think the SEC is sort of done and they're just going to see how things play out, or are we expecting any enforcement actions, anything that you think they're going to try to make their mark on?
I think you'll definitely you'll see SEC enforcement, CFTC enforcement actions will continue in the fraud space, and then I think you'll see the no action letters, the interpretive guidance will probably come out in the next year or so. And that said, I think for those who have sought that guidance will be okay, but then I think for those who have not and have still sat on the sidelines should be a little wary, because I think that enforcement is going to be right around the corner for those entities that didn't take that relief at the outset.
I do want to get back to the exchanges in a bit, but first of all, let's go to the state level. We've been talking about the federal. Wyoming has its legislation. Let me ask you guys, Anthony, you may want to explain it, and also, is it useful? It's just one state. I'm not sure there's a big market in Wyoming itself, but where do you see the state law playing out? And Jeff, is that something that Securrency is involved in trying to shape?
We've not been shaping efforts at the state level. I love it when anybody tries to innovate. So this is playing on the international level as well. Small jurisdictions are pivoting, trying to lead the world in advanced delivery of financial services. And Wyoming's trying to do the same thing in the United States. So I applaud the effort. I don't know if a lot of capital is going to move to Wyoming, but it's certainly going to help, right? I'd love to fly to Wyoming.
Yeah. Arizona too is now, but they just announced another sandbox.
And basically, the legislation just reiterates what we've been talking about with the Howey test. That you're not billing it as an investment, and you need functionality in tokens. So I don't think it really gets us down there, but at least states are paying attention to it.
I know, like, the North Carolina Secretary of State Securities Division really does want to sit down with people, and I think what a lot of people don't realize is that states can actually move faster on enforcement actions than the SEC can. So it is something you have to keep on your radar. And also that might be a good place to start with speaking to a regulator, because they know more of the state's landscape. Like, maybe like North Carolina, you know, we're not exactly Silicon Valley, but, you know, we have like this interesting mix of very low tech and very high tech in the same state, and they're here to serve that entire population. So, you know, remember that there are your state regulators as well.
They had a decision a few weeks ago, which wasn't really anchored here in North Carolina, right? It was kind of incidental, but it was a very strong decision. Yeah. Now, North Carolina, unlike many states, can have a fairness hearing for an offering. Is that something that can be used for a tokenized securities offering?
They certainly want, it hasn't been set as a precedent yet, but they certainly want people to come and sit down with them. And they've asked me, please make this message known to everyone, that we're here, we want to learn from you and talk to you and figure out a way forward. So for what that's worth, you know, take that from this meeting.
Let's move away from securities offerings and on to exchanges. So Elizabeth, what's the status there? And the CFTC issued some advisory about a month, within the last month, I believe it's been.
That's right. So the CFTC kind of has been thrust in the forefront of this because of their offering of Bitcoin futures on CME and SIBO. I think it was a couple weeks ago, the commission, two of the divisions issued a guidance for exchanges that offer virtual currency, that offer derivatives based off of virtual currency products, which was interesting in that it, sort of set out the guidelines that those exchanges, such as CME, SIBO, need to be aware of, but that it made clear that as part of their obligations to the commission, they had to have information sharing exchanges, or agreements rather, with the entities that comprise of the settlement for those futures. That opens up those exchanges like the cryptocurrency exchanges to offer the spot market data, even though they have jurisdiction over the futures markets for some leveraged and retail spot market transactions and those instances of fraud, but that they can go down into the spot market and get that information, and they have the expectation for these futures exchanges to be able to provide the commission with that spot cash market data, which I think will bring more enforcement actions, provide more information to the commission. And you're already seeing that with the recent CFTC DOJ probe that's been reported by the Wall Street Journal into possible manipulation, spoofing, wash trading in the Bitcoin markets.
Securrency works directly with exchanges or with your clients and getting their exchanges.
That's right. Our core product is going to enable a secondary exchange of tokenized securities. So when you talk about exchanges, I think it might be helpful if you think of it in three buckets. The first bucket are those cryptocurrencies that really have achieved the status of currency. And there's only one, now two in that category, Bitcoin and Ether. The next category are the hundreds of utility coins that want to be in this spot, but they're not there yet, and they're kind of in a regulatory no man's land for the time being. And the third are tokenized securities, which we focus on. It can be a private company who wants its shares to be able to be traded and exchanged. And so this is where it could be revolutionary, because if you create a robust trading environment in private placements, that's going to make it more desirable to issue them in the first instance. It's like, are you more likely to buy a car that you can drive 20 years or you can trade it in 3 years? It's kind of the mindset. So we expect that there will be people probably using our technology, applying for alternative trading system. I call it a license, that you really just file a form ATS and hold your breath for 20 days, and then move forward if they don't say no. Filing ATSs using Securrency's exchange protocols.
Great. We're getting close to the time, so let me open it up to questions if anybody has any.
Yeah, we've got about 5 minutes to go. I was going to say, if you want to open up the questions, if we can get the lights also, we'll be able to do that, and we'll get some questions. And honestly, outstanding panel. I was going to say that's a lot of information that, you know, it's great to hear that in the space that it's moving on, you know, that some clarity is coming, and that there's a lot of people, you know, it's certainly different than 2, 3, 4 years ago. There was a lot of no man's land, for sure.
One of the things that I'm hearing here is that, you know, with the regulators opening their ears up, there's a really human moment going on here, saying, hey, look, this thing is moving so fast. We need to hear from you on the ground level so that we can inform ourselves. My question is, how prepared are the regulatory bodies to onboard that information and create actual models? Because it sounds like they need to use it for enforcement, and from enforcement, that then goes up to the chain to Congress, which moves a lot slower for a variety of reasons. So my question is just like, how prepared are they to actually onboard that information and make it really useful?
So on Thursday, the small panel in Washington, D.C., somebody asked Wyrick, the crypto czar, well, you've been meeting with all these people, are you going to put that information out? I mean, that's kind of the same question. And it was like, oh, yeah, we need to kind of figure out how we can make those lessons learned available. So other people are asking the same question. It's great to have this dialogue, but how are you going to push the information out so we can actually have defined guidance and know what's good or not? So in addition to, so the speeches were also mentioned as a way they're going to put out some information. But like 30 years ago, there was this telephone book. You called the SEC with a question, they gave you an answer, and then they actually published all the results of these phone calls. So, you know, maybe they could do something like that.
I know on the CFTC website, I imagine the SEC has it as well, where the no action letters that are granted and that relief is posted on their website, so you can go see it. And I think that's right. I think you're going to see speeches. I think you're just seeing more guidance, more advisories that are put out, like the one the CFTC just did for virtual currency derivative products, the comments by Hinman. If you go on the SEC website, his speech is printed out there, and it has that sort of his questions for you to consider when you have your product. So I think you're going to see a lot of information being pushed out that way.
And that's quite, I think that's safer rather than rushing to actual regulation or law, because you can modify it. You can live with it and see what that's doing, and then to continue to do the dialogue and see what's going on in the marketplace. So I think that, but I think you're right. I think guidance will be the way we're going to see things happen in the next 6 to 12, 18 months.
Okay. Anybody else got questions before the end there? Okay, well, thank you very much. I want to thank the panel very much for your time and excellent.